Welcome back. It's session number 11. Today we will start with the topic of data protection and regulation, which will be, in a way, the way of implementing responsibility by legislation. And this will be the topic for the next 3 sessions, actually, and also for the remaining sessions of this lecture. Before, in the last week, we will have the Klausur. Please be here. Also to the people online and in the recordings, the Klausur, the exam, will only be available in person, on site here in the lecture hall. And you need to be very much on time. Be here at 2 p.m., not 2:15. Okay, but let's get going because we have so much to do. As always, let's start with a little recap of the last session. Last session was on the important notions of responsibility and explainability that are often used in the context of AI ethics in particular. You know all these debates of a lack of explainability of AI decisions or AI outputs in general, and also these conundrums about who is responsible when an AI does this or does that. And the content of the lecture was to demystify that notion of responsibility a little bit. First of all, I think it got clear that responsibility can refer to being responsible for something that already happened, and then the status of being morally deserving of praise or blame for something that was some act that was omitted. And the other thing was all this whole topic of an attitude. Let's call it an ethos, to pick up this Aristotelian notion. In German, it would be something like Haltung oder Ethos. But Haltung is difficult to translate Haltung to English because is it stance, is it attitude? It is something of both. This is why in English I often just say ethos. An attitude, a stance, an ethos of striving to assess one's own abilities and the possible consequences of one's action in relation to moral obligations and aligning one's actions accordingly. It was also clear that this roughly correlates with 2 temporal dimensions. The one is the more forensic, if you will, the issue of responsibility attribution. Something happened, and now we want to know who is morally to praise or blame for the act, whose fault is it, or whose responsibility is it. And this is the backward-looking or ex post perspective on responsibility, while there is also this forward-looking responsibility about when it's about acts of the future. And then responsibility is not about attributing responsibility to you for something that might happen in the future, but it's more that it then opens like the perspective of we could make the whole thing a matter of an attitude. That is, how can we best hold ourselves into some situation, or can we best act in a situation, or what ethos would entail a responsible attitude in a certain agential configuration or action or scene that is unfolding, or relationship, or vis-a-vis a certain technology or investment decisions, and the list continues. In the philosophical traditions, I mean, responsibility is already out there since Aristotle. In the last lecture, there were also more modern positions. And like, if you take all this together, I think what you can say is that responsibility might entail on at least these 3 pillars, or rest on these 3 pillars. The one is that you can only be responsible when you act voluntarily and if you are in control of something. Something that is at least in the ex post perspective. You cannot be responsible for something that happened if you did not be in control, if you weren't in control. Concerning the future, this condition is a little bit more tricky because maybe whether you are in control or not can also be an effect of how you behave. Yeah, you can kind of take control or share control with others, or like actively make it something that you interfere with instead of closing your eyes to something. Yeah, irresponsible behavior in the forward-looking sense could always be like, or a prime example of that would be to look away and to seemingly not be in control while you could be in control, and this could makes all the difference. There's also this knowledge component in it. Yeah, responsibility entails in the ex post version that you must have had some knowledge about what you do and what the consequences might be. If you are acting completely ignorantly, it's hard to attribute ex post responsibility to you. Although, of course, maybe this is a difficult question, because then you will have to ask, okay, what could he have been expected to know? Or did he really kind of go a reasonable length in getting the knowledge he needs? Yeah, if a child just sits in a car and starts driving, yeah, is the child responsible for an accident or not? I mean, first, it's a child. Second, the child did not have training in driving a car. And then we can say, well, maybe the child couldn't really know. Okay, then let's say a 40-year-old person who never drive a car and never took driving license sits in a car and drives a car and makes an accident. Yeah, then we can say, okay, it's a reasonable expectation that you know that you cannot drive a car without driving license or training, so you could have known. Yeah, even though you might not have known, but you could have known. And then you end up in difficult questions. But with the forward-looking perspective, the knowledge component means also, again, make it an active issue for you. Yeah, make it a quest for you to know. You should want to know what happens, and maybe even more than you need to know formally by any formal requirements. Yeah, when you work in AI or in software development, yeah, you can restrict yourself to, oh, my boss asked me to write these lines of code, or you can say, I want to know what this will be used for and where this goes, and what are the implications or the misuses that potentially might happen, and so on. That would be responsibility taking in the forward-looking sense. And this answerability concept that went back also, I think you debated that also in the discussion group, is this being available to stakeholders, to those who might potentially be affected by your action or decision or whatever it is. Yeah, this is kind of what I just told you. I think it is also, as you will have noticed, clear that in this lecture I have a clear tendency for the forward-looking notion of responsibility. Yeah, it's more the idea of the lecture to inform an ethos or a certain moral attitude or politically, morally enlightened attitude of dealing with AI, and maybe even of dealing with your own skills in the context of AI, yeah, where to bring them to use, where not, so on. More than going into the forensics of the trolley problem and then ex post determining whose fault was it or whose responsibility was it that the car killed the 3 old people and not the 4 kids and so on. And this is a little bit in line with this whole idea that virtue ethics, in my opinion, becomes relevant again, or maybe in a new way in the concept of AI ethics, because AI ethics is an ethics that deals with a new technology that has open-ended applications and consequences. Yeah, it's very hard to kind of enumerate the consequences AI technology will have on society. And if you can, and this prevents teleological or consequentialists approaches, roughly speaking. And in such a situation, when the consequences are very open-ended and very uncertain, of course, what you can do is inform the attitude with which all this is being done. this is why I would say that virtue ethics gets a new relevance or a revived relevance in the context of AI ethics. As I think it was spelled out already last time, with regard to responsibility, that means actively taking control. Yeah, this is the control condition of responsibility. Actively seeking knowledge and sharing knowledge if you have it. Yeah, for instance, if you're a company, it's always your decision whether you keep something a corporate secret, for instance, an algorithm or a model, or whether you make it accessible for people to scrutinize or to acquire knowledge, what your tools can or cannot do, what the risks might be, and be answerable in the sense that you should be available. Maybe customer support should be done by persons who are answerable instead of only chatbots and so on. This was the brief and sketchy overview of this important notion of responsibility. I think the lecture was dry and theoretical enough, so let's not make it longer than it needs to be. We are now in the third block of this lecture. It started already last week, and the third block is where the lecture turns into normative questions, like questions that answer that deal with issues of what should we do or what shall we do, how shall we behave, how could we prevent certain harms, and so on. Yeah, the first block was more the conceptual clarification. What is AI? What kinds of harms is it? What power is involved in AI? The middle block was a little bit this kind of what is it doing to us now? Will it kind of overwhelm us politically? What ideologies is it based on? What structures of our own awareness or thought are involved? And now, after all this has been deconstructed, we can turn to answering normative questions. That is basically the idea. And as I would say, one of the biggest, or to me, most important parts of this, but also the main focus of the remaining lecture, is data protection and the protection of fundamental rights in relation to AI. And this is basically what I will outline to you today. Next week, we'll turn to the AI Act, the EU AI Act, which is a separate piece of legislation. And then in the third week, I will give you some insight into cutting-edge research question, mainly also from the research we are doing here in Osnabrück on these topics. Before we start into data protection, I was planning to kind of deliver the one part from the lecture on AI and the state on the rule of law. Because now that we are in the kind of realm of regulation, maybe we should start at this point. Before then we get to the data protection topic. And this is now maybe something very broad, but I find it very important. And I hope you agree with me. Let's see. I want to kind of, in this section, I want to talk about some, maybe 3 or 4 very fundamental principles or legal doctrines in democratic societies that have been growing and developing over the centuries in many legal systems in the world. And of course, the first is this principle of the separation of power that was already touched upon in the session on power, which was, I guess, session number 3. There you had it already in Locke, if you remember well. The idea, or this constitutional principle that divides state authority among 3 independent branches of government in order to prevent the concentration or abuse of power. And why do we have this? I mean, people like Donald Trump and his followers maybe need explanations, again, on this topic that we have for many decades maybe not enough explained at school or in education. Why do we have this principle? It is there, of course, to prevent something like tyranny or autocracy. yeah, that there is a single, that we prevent that there is a single entity holding absolute power. And this works by this famous idea of checks and balances. Each branch of the government, 3 branches, can limit the powers of the other branches. And then if they are independent, then you have this kind of mutual checks and balances, and a system where where you don't have an easy, simple one single point of failure. For instance, if a fascist person gets into one position, then the whole system will be fascist. This is then being prevented. And the rule of law principle is also intimately kind of connected to this division of power principle, because it means that there is some independent courts, independent judiciary that ensures that the laws are being applied. Yeah, I mean, it's not enough to have laws, but you also need to apply the laws, and you need to apply them equally to all entities in a society, be it individuals, be it people in the government, and also corporations and so on. Yeah, so the classical division of powers that we have in the modern times is between legislative, executive, and judicial. The legislative makes the laws. It's, for instance, the parliament, Bundestag, Congress, chambers, and so on. The executive is the government in the more narrow sense. It implements and enforces the laws. That is, for instance, in many systems, the president or the prime minister, depends on the system. And here in Germany, it's the Kanzler and their ministers. And then there is the judicial branch of power, the courts, yeah, the system of courts that interprets the law and adjudicates disputes. And for instance, here in Germany, we have the Bundesverfassungsgericht as the highest supreme constitutional court, and in other systems you have other highest courts. Yeah, they usually come in hierarchies, but not necessarily. Yeah, they might not, but in many cases they do. Where does this actually come from? The first kind of ideas of this is really already in Aristotle, yeah, and this is very long ago, 2,500 years. That the idea that there are 3 functions of governments, he writes that in his Politics, that was legislative, magistrative, and judicial. So he did not have exactly the same 3 things or branches, but the idea that deliberation should be distinct from the executive was already there. And then John Locke brought that up famously and impactfully for us even today in the early modern times. Also, he had the legislative, the executive, and then the federative power. I talked on that in session 3. Yeah, the third branch is not exactly the same. Federative power is the kind of acting the whole, when the state acts against another state in the external relations between states, for instance in war. And then Montesquieu is the one who came up with the system, or with this rough idea of the 3 branches that we still have today. Another distinction that I find highly relevant, and that opens you an understanding for many things that are going on in the world around digital regulation, is the distinction between common law and civil law. Who knows the distinction between common law and civil law? Okay, so it's not a waste of time explaining this now. This is a distinction, a fundamental distinction of legal systems in the world. There are more than the 2 options of common law and civil law, but I will in this lecture only look at these 2. And this is mainly a matter of the global north. Yeah, so I'm kind of blatantly excluding looking at the religious law systems, for instance, that are more prevalent in some countries of the global south. So what we are looking at here is the systems with blue color and pinkish colors here. Pinkish And you see that pinkish is common law. You see that the pinkish is in North America and also in the UK, while the blue, which is here the coding for the civil law tradition, is in continental Europe. So there is a fundamental divide in the way legal systems work between North America and continental Europe. This is what I want to talk about now. This is why I picked these two. So let's compare these two legal traditions briefly, and I really try to boil it down to what I think one should know. In the common law tradition originating from England, the common law tradition originates from England, while the civil law tradition originates from the Roman legal system and is then spread on all of the continent of Europe. And maybe the primary distinction is, what is the prime source of law? Yeah, where does law come from in these systems? All these systems have parliaments. Yes, the role of the parliament will be detailed further down. But the primary source of law in common law is case law. And this is what the colleague up there just said. Judicial decisions set precedents, and this will then be law. This is how it works in the United States and also in England, that court decisions form precedents, and then future cases that are similar have to be kind of brought in an analogy to previous cases and decided in a similar way. Yeah, this is kind of a chain of precedents. So the law that they have, the written law in the statutes, that is much less extensive, and the law will then be detailed and formed by the courts actively. This is not the case here in Germany mostly, where we have codified statutes law, which is decided by the parliament. It is very extensive, contains many, many details, and then the courts apply the law to a case. Yeah, you bring a case in front of the court, and then the court will have to subsume your case under the law that codified it, and then decide accordingly. And then this is not necessarily setting a precedent. The one thing, we do have some case law here in Germany. Where do we have case law in Germany? The Bundesverfassungsgericht does some case law, yeah? Richterliche Rechtsfortschreibung. When the Bundesverfassungsgericht interprets the Constitution or the Grundgesetz, it might come up with doctrines that then will become kind of case law that will be applied. Sometimes in Mietenrecht, there are decisions that have case law character because it gets so detailed that it might not be fully codified in the law, and then a court case sets a precedent, and then you refer to the precedent. But generally, the US legal system is heavily built on this idea of setting a precedent in court, while the continental European system delegates much more of the normative work to the parliament, and the courts only apply. Yeah, this is something, maybe the takeaway that you could take away. So the role of judges is different. Yeah, in the common law system, judges interpret and make the law through decisions. Case law is then binding, while in the continental European system, the law is being applied. And the legal reasoning in the common law system is then often by analogy. Yeah, how analogous is the present case to some previous cases, and to what extent can we apply some existing case law, so previous decisions to this decision. While here it is more a deductive style of reasoning. Yeah, you need to subsume your case under the rule that applies, and then it is kind of a deductive. The consequences are then a more deductive thing, although there is discretion and so on. And then, of course, what is the role of parliament? I mean, in the codified law system, which is the civil law system here, it's quite clear. Yeah, the parliaments set the codified laws. And in the common law system, of course, you also have parliaments. It's not that we are going without elected parliaments in the common law systems, but they maybe and they can also kind of pass laws and legislation, yeah, it's statutory law, which would then be a piece of law that is not a case law, but a law that was decided by a parliament, and that can override case law that was kind of spelled by a court. Maybe this is, for instance, to correct or to update to a new level of societal situation, like if you want to update the case law and so on. That is the typical situation where a parliament could intervene. This is an interesting distinction because it explains a lot concerning the contemporary kind of, let's say, dissonances between US politics and companies on AI regulation versus in Europe. Because the way of going in Europe is always lawmaking precedes the application of the law to certain problems that might need decision in front of a court. While in the US, you more have the state of affairs that when something goes wrong, then you bring it in front of a court, and then there will be a decision, and that decision will then set some case law. Yeah, you see that legislation in the sense of case law always lags behind in these common law systems, while they can precede the application in the civil law systems. We also have in Europe the precautionary principle, yeah, the explicit legal doctrine that you should, especially when it is about risky things, really take precautionary action in law so that you legislate to prevent risks to materialize. This is comparatively unheard of in the US-American system, and that is also maybe shaped by this hugely different kind of legal system perspective. Another important concept is this idea of the rule of law. In the German system, it's Rechtsstaat. I bring the German term here because this is in this case, you would even use the German term in English debates when you really mean the Central European version of it. It's a foundational principle of democratic governance, asserting that all persons, institutions, and entities, including the government, are subject to and accountable under the same law. Maybe this is obvious to you, but it is not obvious to Donald Trump and others that everybody, including people in government and government entities, are subject to the same law and to court and judicial oversight and accountability and liability and so on. So the principles, this rule of law or Rechtsstaatsprinciple, actually there are two principles because the one is really tied to the common law tradition while the other is really tied to the civil law tradition, and I kind of merged them here on one slide to only have one slide and not two slides. I tried to pick the commonalities between the two principles in this slide here. But what they all have in common is a clear understanding that laws have to be publicly known, clear, consistent, and stable. Yeah, you cannot pass secret law, then it will not that will not be compliant with Rechtsstaat. Laws have to be worded very clearly so that everybody can understand them. Although I rarely find this is the reality. They have to be consistent. Yeah, there cannot be internal kind of inconsistency. The one says this and the other says something opposite. Stable means it cannot change every second day or week or year. It has to be reliable in some way. Laws apply equally to all. Everybody needs access to justice. Yeah, it's the right to legal redress and to a fair trial. And part of the fair trial is also a transparency thing. Yeah, we had that in the lecture on AI and the state. If you do a decision, for instance, automated decision making in government, if this leads to intransparency, then it is hard to enable a fair trial because then the judges cannot kind of check the reasoning behind the decision. So that will then hinder the principle of the rule of law or Rechtsstaat. And the judiciary has to be independent. Yeah, courts must be impartial and empowered to enforce the law also against the state and against the government. I mean, yeah, how do you get impartial judges? Hard and heavy topic. Look at how it is being done in different countries. For instance, the US, or how it is being done in Germany. I think this is maybe a lecture in its own right. And at least in the richer concept of Rechtsstaat, yeah, Rechtsstaat is the somewhat richer concept when it comes to normative aspects. So Rechtsstaat definitely includes a commitment to the protection of fundamental rights. The state is obliged to uphold fundamental rights and civil liberties in all of its activities. This rich and substantial interpretation of Rechtsstaat is in the rule of law tradition sometimes contested. Yeah, some rule of law schools would say that rule of law is only a procedural requirement, while fundamental rights are a content or a substantial requirement. So if you are a formalist or proceduralist in the rule of law, then you will say that fundamental rights are not part of it. But I think that even in the States there is a clear impact of the substantive interpretation of the rule of law that definitely contains a commitment to the fundamental rights. Another principle that is intimately related to this here, the rule of law, and this is maybe the practical part of it or the procedural part of it, is often called due process. And I'm bringing this here not to bore you, but because this is something that's now being touched upon when we debate, for instance, what DOGE is doing, or whether we can fight bureaucracy through adopting AI. Yeah, this is what you really need to know. Due process is a constitutional principle that guarantees fair legal procedures and safeguards individual rights when the state acts against a person. Yeah, this is now really the procedural level of the rule of law, and it entails a right to a hearing, a legal representation, an impartial tribunal. Yeah, this is it's kind of the implementation of this right to justice that you had on the previous slide. Also, a reasoned decision. You have a right to a reasoned decision. Yeah, it cannot just be decided and then please accept, eat it. You have a right to a reasoned decision, a right that is at danger when decisions are being taken on mere statistical premises, as I tried to outline in this lecture on the AI and the state. You also have a right to appeal and review, yeah, legal redress, a right to the Rechtsweg, Widerspruchsverfahren. This is basic constitutional rights, and it's good that they are there. And also, the state cannot act at will. The state can only act in a way where there is a legal basis. Yeah? So, for instance, even administrative state departments, they cannot just decide at will or as they like. They can only decide what they are enabled and how they are enabled to decide by law. Yeah, it is a little bit different from private companies. For instance, a private company can or cannot take your Auftrag, but the state must do it. Yeah, if you apply for something at the state, they will have to handle your application. They will have to review your case. They cannot say, no, today no, or today no, they can, but they cannot say no infinitely. And in the Rechtsstaat tradition, we have similar principles. I just go through them. Right to a fair hearing, right, access to justice, requirement for a reasoned decision. State actions must comply with the law. Yeah, in Germany, you call that Gesetzesbindung aller Staatsgewalt. Es ist im Grundgesetz verankert. State action must be proportional. This is important. It's a Verhältnismäßigkeitsgrundsatz. Yeah, the principle of proportionality. For instance, when you I don't know, when you committed a minor thing like going without a ticket or parking your car in the wrong spot, it will be disproportionate to charge you with €1 million or to put you in jail. unfortunately, there are many people jailed for going without a ticket, which is why people are fighting against this in Germany. Yeah, there is always this Verhältnismäßigkeitsgrundsatz, which is also a constitutional or a central principle of Rechtsstaat, that the legal consequences have to be in some kind of proportional relation to the wrongdoing or the reason for the consequences. And compliance with fundamental rights and human dignity. Okay, that was kind of the part that basically orients us in the kind of legal system that we live in. And now let's bring that into the direction of data protection. This is now a very specific legal domain. You will see the connection to it, but before I inserted this new slide compared to the last years because of the feedback I received. And the feedback I received is that I should highlight much better that data protection is not the same as privacy. And maybe this is one of the core takeaways of the lecture. Data protection is, if you will, an ethical, political, or regulatory pursuit or concept or business with the objective to mitigate power imbalances around the processing of personal data. You will learn what that means in the next slides, so don't worry. I just want to kind of put it up front here, this comparison, and I will get back to it on one of the slides. So data protection is about balancing power asymmetries that arise through the processing of people's personal data, while privacy, on the other hand, is something much more individualistic. Yeah, privacy is a right of individuals, if you will, be it a moral right or a moral value or a legally enshrined right to control access to their personal information. Yeah, privacy often comes with this association of a private sphere, that like some domain of information that is deemed private or even intimate, that only you can access or control who has access. Yeah, privacy is this very individualistic thing, while data protection is really a political topic, because data protection only arises when the infringement of the private sphere is connected to power asymmetries. Yeah, that information that we collect about many people can be leveraged against people and makes for a power position of the actors who have this information. The problem is there is a huge confusion of these two concepts in translations, because often data protection, the German Datenschutz gets translated to privacy, and the English privacy gets translated to Datenschutz, data protection in German, although these are actually two distinct things, and instead of like translating privacy, you can also say Privatheit, and translating Datenschutz, you can also say data protection. But for some reasons, and I think the reasons you saw on the slides with the different legal systems, once you start speaking English, you are more in this individualistic framework, and once you start speaking German, you are more in the codified law societal perspective. Yeah, it is a translational issue, but it's also an issue of the legal systems, because the US legal system has a huge tendency to not see the power asymmetry and collective aspect about it and boil it down to individual interests, while in continental Europe we are much more inclined to kind of care for the common good or the shared collective interests. So what does data protection protect? The problem is that data protection itself is a very bad name, as has been attested by many data protection scholars through the decades. Data protection does not protect data. At least that's not what it is made for. Data protection protects individuals and their fundamental rights. So the idea of data protection is that you need to protect individuals and society at large against unlawful or abusive effects of data processing. And here with data we mean personal data, by public or private organizations. Yeah, so in particular, data protection aims to protect fundamental rights of individuals in relation to the processing of their personal data. Where does this come from? In the Central European tradition, the German discourse is one of the origins of this data protection. And for instance, in the post-World War era, we had this maybe epoch-making moment where people were fighting in the 80s, in the early 80s, against the census. The German government of that time wanted to do a census. They wanted actually to do a full population census, N equals all. They wanted really to go from household to household, ring the door, and ask people about their demographic data, also where they work and so on. And then there was, here, behavioral and economic information was also planned to be covered in that census. It was the first census, I think now I know better, but it was the first census supported by digital computer technology, so that you also had this, technology. Here in Germany, we don't know what that means, so let's rather be against it. And it was also planned that this census data could be linked to the data from the Melderegister and other civic registers, which is actually quite a decision. And then there was big fights against this. Like people were protesting and taking to the streets. And I think it has the background, and they succeeded. I will tell you on the next slide. I think the resistance against this has the background that, for instance, in Nazi Germany, Hitler did one of the biggest and most comprehensive censuses of all of human history. A couple of months after he took power, he contracted IBM to do a mass census of all of Prussia. Prussia, this German state, of a couple of million. And they asked a comprehensive set of demographic data that was then even used to abuse the people, to murder people, to put people in concentration camps. Maybe that is some of the historical roots of the resistance against the idea of a census in the 80s here in Germany. This case was famously brought in front of the German Constitutional Court, and maybe preceding this, and the German Constitutional Court decided against the census in this form. So the census was then prevented by the German Constitutional Court. And in this judgment, the German Constitutional Court came up with this famous notion of informational self-determination. It was an interpretation of other principles in the German Grundgesetz. The principle of informational self-determination is not a Grundrecht, a fundamental right according to the German Basic Law, but it is derived from the principle of free personality or freie Entfaltung der Persönlichkeit, so your right to personality, but also dignity, human dignity, and other basic constitutional principles. This is an example of case law in Germany, that the Constitutional Court said there is something like a right to an informational self-determination. It is not written in the Constitution, but we derive it from what is written in the Constitution, and as of then, this thing is there. Classical example of richterliche Rechtsfortschreibung or case law in Germany. The Verfassungsgericht, however, did not invent this notion of informational self-determination. That was already around for more than 10 years at the time, because it goes back to a report that Wilhelm Steinmüller wrote for the Minister or Ministry of the Interior, for the Interior Ministry. It was a researcher at that time, a legal researcher, and he was contracted to do kind of a research report, Forschungsdossier on data protection, and he came up with this. It was Grundfragen des Datenschutzes, that was the title of this famous document, and he came up with this notion of informational self-determination. And he recognized as a fundamental right, that was then recognized as a fundamental right by the German Constitutional Court in this famous verdict. It's also interesting how the court justified the decision. And this is also worth remembering, I think. The court, the judgment, the spell, it's on the internet. Download it, read it. It's interesting reading. But I just pick out 2 points here on the slides. The one is that data processing by information technology can threat the liberal constitutional order. Yeah, that was one of the lines of argument of the court. Yeah, because the court had to make the case, why is this such a threat? Yeah, and in this case, such a threat that the liberal constitutional order is in danger. And the reason, according to the court's judgment, is that citizens who are unsure whether deviant behaviors will be recorded, stored, or shared will try not to be noticed by such behavior. Yeah, it's the idea, and by deviant we mean politically, yeah, for instance. So the idea is, if the state, with all their political kind of the parties who are ruling right now and so on, if you as a citizen are not sure whether the state isn't observing your, for instance, political, but also religious or sexual behavior, if you are unsure about that, then, so the idea, you might change your behavior in such a way that you avoid behaviors that you think might be deviant. And this then represses the diversity of, for instance, political positions or the unfolding of diversity in sexuality or in religious exercise and so on. Yeah, this is the idea that if people feel watched, they will kind of adapt their behavior to the more normative. And this was then turned into law here. This is actually the basic principle of panopticism, also going back to Foucault. I cut out these 2 slides from this lecture here, but if you are interested in this point, then you can have a look at them. And the court argued that such an influence on your behavior by you feeling watched is not only a danger to you alone, but a danger to the liberal constitutional order, and so to the common good, because, for instance, it will narrow down or reduce the diversity of political Willensbildung and so on, political participation. So he said that self-determination is an elementary functional condition of a free democratic community. Yeah, so this is the kind of the German history of it. The need for data protection arises in the context of informational power asymmetries, and this power asymmetry is not reached when data of 1 person is recorded, or of 10 persons, but here the power asymmetry was reached because it is this kind of broad, comprehensive census that will record information about anybody. But of course, power asymmetries can also have different bases, and we talked a lot about power already in the context of AI and big data companies, and you can imagine that power asymmetries got bigger and smaller since the 80s. Or looking from now to the 80s, we might even think, this is what you were protesting against. Where are people protesting now? Nobody. So times really changed. Yeah, here this is maybe where power asymmetries could originate from. The data protection aims to limit the imbalance of power between individuals and data processing organizations, and this is now, I think this now gives us a better understanding of this slide here, yeah, that I brought already. In privacy, you only look at it, what does it do to you, and there is harm, moral harm, other harm to an individual for sure. But data protection is when you look at the same problem from a societal perspective or from a more aggregate perspective or systemic perspective and say that, for instance, it can be threatening to a whole democracy if people get watched or observed or tracked, or if certain entities in society, be it the state or be it private companies, get into a very powerful position based on the aggregate data or the data processing they do, which often is then to do with aggregate data or data aggregation. There is another key distinction which is very important besides privacy versus data protection. The other key distinction is data protection versus data security. This is actually also a very, very frequent confusion that people boil down data protection to data security. Data security is this encryption, redundant storage, access barriers to computing systems, maybe also like not only passwords, but also like the building should be locked and safeguarded, like for instance a data center. So in general you have always these big 5 things in data security: theft, loss, modification, delete, and fraud. These are kind of the attack vectors or big attack vectors that you want to protect your data against. This is really about protecting the data from, for instance, unintentional modification or loss or theft. And this is part of data protection, but only one small part, because it's, if you will, the technical aspect. And in contrast to this, data protection is really a political issue. It's the protection of your rights against harms, and it concerns also societal impacts of data protection and not only individual impacts. Yeah, this is the second maybe important distinction that you should memorize, because it is so often that data protection is being confused with data security. Yeah, let's get to the next part. I'm sorry, I just see that the numbering got wrong. This is already part 3. Let's switch back to a legal topic again, because I said it so often right now, or in the last hour, that data protection is about protecting your fundamental rights. What then are fundamental rights? And this is also an important piece to remember, and also, as I now know from the experience of the last 4 years, something that people do not usually know. First, where does it come from? That data protection is tied to fundamental rights here. It's, for instance, in Article 1 of the GDPR that states that the regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data, and then this regulation protects fundamental rights and freedoms of natural persons. Yeah, this is how data protection is linked to the fundamental rights. And now, what are fundamental rights? Fundamental rights, and this is what I just meant that usually people don't know, fundamental rights are essential rights of all members of a society against the state. Yeah, primarily it is rights you hold against the state. It's rights that are usually enshrined or of constitutional rank. Very fundamental. They are granted as permanent, durable, and enforceable in such constitutional systems, and they are primarily what you would call defensive rights of the citizens against the state, and indirectly also against private parties. I will have a nerdy slide later on how to explain to you how this kind of indirect function emerges, but maybe the first thing is that we appreciate here that fundamental rights are rights that are guaranteed against the state. Why? If you remember the session number 3 on power, yeah, we had these contractual theories where people said, okay, we endorse some political sovereign or other political system that to which we delegate some of our powers, so that this political system will exercise some of our collective powers in the name of the collective or in the name of the common good. Then you see that the state, as a huge accumulation of power, is in a very special relationship to the citizens. Yeah, it is endorsed by the citizens, at least in theory. And of course, if such a big power accumulation is therefore arising from this endorsement, of course, the citizens also need to reserve some rights against the state. That is, for instance, rights that safeguard against misuse of these powers. And fundamental rights are fundamentally rights that safeguard you against state abuse of power. Here there are some examples of fundamental rights. Rights to self-determination, liberty, due process of law, inviolability of the home, privacy of correspondence, right of asylum, right to freedom of movement, to the protection of personal data, freedom of thought, freedom of religion, freedom of expression, peaceful assembly. Yeah, these are fundamental rights, only examples of fundamental rights. It's not a comprehensive list. And the right to data protection is in the EU also a fundamental right, because the EU has the Charter of Fundamental Rights, and in Article 8, which is titled Protection of Personal Data, it says in Article 1, everybody has the right to the protection of personal data concerning him or her. This is actually progressive and worthwhile preserving, because as you see, this is not only a right to privacy, not only a right to be left alone or to have a private sphere around you, but a right to data protection is a right that will safeguard you against power asymmetry, so against powerful actors who can use your and others' data against you and other people. And this is a fundamental right in the EU. This is the nerdy slide I just announced. So if fundamental rights are primarily rights of the citizens against the state, how is it that we now talk about data protection nowadays more often in relation to private data processors than in relation to the state? Yeah, you remember that in the Volkszählungsurteil, the German census verdict of the Constitutional Court, it was really the state who would be the data processor, because it was a state-run census, while nowadays most of the data protection issues we're facing involve private companies, which are now much more powerful data processors than any state could be. Yeah, and the thing is that the fundamental rights also hold against private entities, but kind of, if you have to think around the corner, if you will, and you call the subject, you distinguish two dimensions of fundamental rights, and the one is the subjective dimension and the other the objective dimension. I said this will be the nerdy slide. The subjective dimension is this dimension of you subject, like you personally, you individually have a defense right. You have a claim. You can kind of fight against certain infringements based on your fundamental rights. This is the subjective, called the subjective function. But the objective dimension is something more forward-looking. Yeah, you see this distinction again: backward-looking, forward-looking. The subjective dimension, defense right, is you can do it when some infringement happened to you, But the objective dimension is that the state has the duty to generally maintain the constitutional rights as an objective order of values, ja, irgendwie so Grundordnung. And fundamental rights establish the duty of the state to prevent violations of fundamental rights by the state and by third parties. Wait 1 second. So that there are fundamental rights not only means that you have a claim against the state if the state infringes your fundamental rights, but also that you have a claim against the state that the state prevents anybody, including third parties, from infringing your fundamental rights. Yes?
That's why, if you remember a couple of years ago, a bunch of youth activists going to court, the EU court for climate change reform, and saying that it's the current system is defying their fundamental rights. Is it then through the objective dimension?
Certainly. Yeah, this is a very good example. When the German Constitutional Court decided that it is a matter of the protection of the fundamental rights of the young generation that more climate action must be taken by the German government. You call it intertemporaler Grundrechtsschutz, intertemporal protection of your fundamental rights. Why intertemporal? Because the effects, the harm, will only occur in 50 years, but you have to protect it now. Yeah, this is the intertemporal, between the times, dimension of that heavily forward-looking protection of fundamental rights. And yes, very good association. This will then be related to this objective dimension of the fundamental rights, which are not only ex post defense rights, but really come with the duty of the state to be, within reason, preventive. Yeah, and not only climate change is an issue that heavily demands for more preventive action, but also is data protection. Yeah, data protection is a preventive regime, a regime. Yeah, if data protection is protection of your fundamental rights, and once the data is leaked, this cannot be undone in the digital sphere, and therefore the whole legislative regime of data protection is set up in a way that not only gives you defense rights, but that prevents, as good as it can, infringements to happen. And that then also holds for or against private parties, because it is the duty of the state to protect your fundamental rights preventively, also from infringements by private parties. Yeah, this is the reasoning. So data protection is a protection in advance. Yeah, in the German legal debate, there is this nice term, Vorfeldschutz. I love it. It's a Vorfeldschutz. Yeah, you have to do it in the Vorfeld. You cannot do it in the Nachfeld, because then it is too late. You must do it before and not only after. Beyond individual defense rights, data protection includes conditions and requirements for processing of personal data. Yeah, this is, yeah, now I try to develop why do we have this heavily complicated regime of the GDPR, because it wants to implement some preventive protection, and for that we need some principles, like a system of reasoning, and part of this is that there will be conditions and requirements for the processing of personal data. There will be requirements concerning transparency. There will be control and oversight obligations, for instance, that data protection officers and supervisory authorities have certain roles. They are independent, yeah. Supervisory authorities, data protection authorities are even independent from the government. Yeah, they are designed in such a way that they can also act against the government in case the government or the state violates data protection obligations. Yeah, so you again see a principle of the division of powers here in the implementation of data protection, and so on. So let's get to some takeaways of this part 3. data protection does not reduce to subjective rights and claims, but includes provisions to prevent harms. I said that. Data protection does not reduce to rights against the state, but also applies to data protection against private actors. I think I said that too. Let's get to part 4. The comparison of the EU and the US situation when it comes to data protection. And in order to enter into that comparison, we will also have to have a brief historical look at the concept not of data protection but of privacy. Yeah, I told you it's two very different things, although they are connected. I gave you some historical glimpse into the data protection, like Volkszählungsurteil, German census, and so on. Let's now look at a very brief history of the concept of privacy, and this history is a very American history, which is why I put it in this part. The classical concept of privacy in the legal realm goes back very famously to the two American lawyers, Brandeis and Warren. It's their last names, I forgot the first names, from 1890, from the 1890s, who invented or gave rise to this famous right to privacy, which became also law in the US. Maybe I have a slide on that later, I don't know, I cannot look forward here. Let's see whether it pops up. But the most elementary notion of privacy is this right to solitude, to a space of your own, yeah, to kind of your room or some really also very physical sphere in which nobody can get into or look into, yeah, a right to be let alone. This is maybe the most boiled down but also earliest version of the notion of privacy. It got a little bit more complicated and demanding when in the 20th century some American scholars refined that notion towards what you would call control theories of privacy. This is a theory saying that you have the right to decide what information about yourself should be communicated to others and to which others. Yeah, it's not only a right to a room of your own, but it's then maybe a right to a room which has lots of windows and you can selectively open the windows to some part of your private sphere for some people. And it should be in your control. Yeah, this is already refined as you see. And then there is maybe the more, even more refined version of it, that is the right to information and self-determination, which is, for instance, also like in the German legal doctrine, it's more than only to control who has access to what information about yourself, but for instance also to which information do I expose myself, and how is this being part of my personality? How do I present myself in a certain, for instance, online, which avatars do I create of myself, so I can maybe play around with different versions of myself. All this would be like freie Entfaltung der Persönlichkeit, yeah, the right to free personality in an even richer sense than only a right to control who has access and who hasn't. Yeah, maybe this, I meant to kind of formulate an escalating kind of a list of privacy conceptions. Yeah, here is the slide that I was looking for. So the first notion goes back to these two cuddly dudes, Samuel Warren and Louis Brandeis, the right to privacy of 1890 in the US. And it is more interesting than how they look like. It is actually when and why did this emerge? And this right to privacy emerged in response to a certain technological development. What was the technological development? Yeah? Camera. Nice. It is a response to the camera plus magazine publishing. Yeah, the colored magazines, illustrated magazines, as you would call them, that could print photos. So what you would see is paparazzi photographers following celebrities, photographing them in their bedroom through the window from the street with a teleobjective and so on. This technology emerged. And This is how the protection of privacy really emerged as a protection of rather privileged people in their homes, which are usually fenced off from the public anyway, but not from the magnifying camera objectives that emerged technologically at that time, and probably curtains were not yet invented, I don't know. So you see that this is a privacy notion that is really very physical. Yeah, it's this technology enabled to intrude into spheres that are actually normally shielded off from the public sphere, and it is a right to non-intrusion. Yeah, in this American context, I think this is really worth pointing out, that this has an intimate connection to the thinking of property. Yeah, this right to privacy, you would never have a reasonable expectation to this in public, yeah, on a market square or on the street. You will not be able to regulate, for instance, this the use of cameras, but when it intrudes in your bedroom from the street through the window, that was the objective of that legislation. And then there was this control theory that emerged in the 60s. I already said that, this is why I'm jumping over it now here. And then, yeah, here, actually the idea of the control theory is still very prevalent nowadays, when in every shitty online interface you have this kind of privacy control options where you can set up who can see your postings on social media and so on. It's important that, of course, this is not data protection, because in this case, Facebook has all the information. You can only configure who of the other users can see it, but the powerful actor is Facebook itself. And this is why in data protection, you have this very fundamental principle that the primary attacker is not, for instance, the hacker or the theft or so on, but the data processing organization itself. Yeah, you are the data subject user of Facebook here in this example. Facebook is the platform mediating all this information, and then there are these third parties, other users or companies, and you can configure who of them sees your information. But the real data protection nightmare is the second person, yeah, Facebook, the platform, not the third parties on the platform, because Facebook has all the information and you do not have a way of withholding it from them. Okay, after this being said, we wanted to look at the situation in the US. And in the US, you do not have such a thing as a general data protection regulation. In Germany and in the EU, it is called general data protection regulation. Why general? Because it holds for all data processing very generally. Yeah, it holds for any instance of data processing without exception. It is not a sector-specific or domain-specific or agent-specific legislation. Yeah, for instance, for the health sector, a legislation regulating data processing in the healthcare system, or a legislation regulating data processing by the state administration, and so on. No, it is a general data processing regulation, a protection regulation, which means it holds everywhere. Okay, there are some exceptions in it, unfortunately, such as military use, but the state is also included. Yeah, it's this rule of law principle. The same rules hold for the state and not only for the private parties. But this is not the case in the US. The US has a large number of, if you will, piecemeal, or it has this piecemeal approach, a large number of domain-specific legislation. For instance, here at the federal level, the Fair Credit Reporting Act, the Family Education Rights and Privacy Act, the Children's Online Privacy Protection Act, the Health Insurance Portability and Accountability Act, the Privacy Act of 1974, and so on. The HIPAA is very famous. Yeah, this is something that maybe one should remember, because you will encounter that here and there. Also, the CCPA, the California Consumer Privacy Act, it is actually a legal statute that employs similarly strong provisions as the GDPR, but only limited to consumer data. Yeah, so they were not able to kind of decide it as a general regulation, but only in the context of consumer data processing. And data protection standards in the United States are generally weaker than in the EU. There is no general approach. This is what I just said. But then there is also no single authority to oversee data protection law in the US. Yeah, there is the Federal Trade Commission and all these single commissions doing the oversight of the single domains and sectors where there is some privacy law, and if they are not shut down by Doge or Trump. But there is not this independent data protection authority as we have it in the EU and its member states. Also, the privacy laws in the US typically apply only to data of US citizens or residents, which is not the case here in the EU. Yeah, it applies to any natural person. The GDPR applies to the personal data of any natural person, not only of the residents in the EU. Most laws in the US apply only to the processing that takes place in the US. So if you offshore your data processing, you can actually circumvent some of these regulations. This is not the case in the EU GDPR. It applies everywhere. If it is done if the data processing is done in the EU, it applies to the data of any natural person. And if the data processing is done outside the EU, the GDPR still applies if the company offers services to anybody in the EU. And there is no general breach notification law, no general storage limitation, no general catalog of lawful grounds. You will learn about the lawful basis in the next slide, in some of the next slides. But the breach notification, this is important. Yeah, that in the EU, you have to get a notice when your data has been breached. This is part of the data protection legislation here, so that you at least know what might come up to you because some breach happened. And also, as a kind of a rule of thumb, you can also kind of memorize that in the US, many privacy legislations are kind of built in a similar mindset to the protection of the private property, the private spaces like home or ground, while in the public spaces and in the public sphere, it is in the US-American mindset much less plausible that you have any protective rights. The US context prioritizes individual autonomy of private actors and protection of individual property, while the EU context prioritizes protection of the personality and the common good, if you will. Yeah, and here, just to fulfill that, I think this comparison has a lot to do with this difference between privacy and data protection, as you see. Yeah, the US legal system is much more focused on individual rights, and privacy is the more individualistic concept, while data protection is about societal affairs. Yeah, we as a society cannot want that the data of some is used against them or against others as a matter of power asymmetries, not as a matter of spying on you. And this is then maybe a legal program that is more oriented towards something like the common good or something like joint participation in wealth and social justice, and it is about caring for a society that does not have such a big difference between the poor and the rich, or the powerful and the non-powerful. This is the objectives of the data protection regulations. As Wilhelm Steinmüller, the German cuddly dude and foundational thinker of the informational self-determination principle, famously said in an interview when he was asked, yeah, what is data protection about? He said, no, es geht nicht um deine Privatsphäre. Es geht einfach darum, eine Technik sozial beherrschbar zu machen. This is actually a very nice quotation. Yeah, it's not about you. It's not about you and your privacy. It is about social control of a technology. Yeah, so a technology, data processing at that time, digital data processing, has structural, systemic, societal implications, and data protection is about getting this under control of the political community and not letting it be decided by the private companies alone. Yeah, this is, if you will, maybe the main difference. I will continue next week with the part 5 on the GDPR. It's a nice cut now. It's not a problem that we did not make it into the last part of today, where I will start introducing the GDPR and its single principles. I will spend the next lecture on the EU situation, so AI Act and GDPR, and kind of summarize all that. Okay, so see you next time. Yeah. I'm still here for questions on the exam and whatever. Yes?
Is there already a date for the retake?
For the retake, no, not yet. I expect it will be somewhere around the first weeks of the next semester. Unless, I mean, we can also arrange for some retake date midsummer, but it depends on who needs it and when they are available. Did you already send me 5 emails or 1 email?
But the ethics exams on the same day as like 3 other exams,
Yeah.
for example, so it was my question if it was possible to
No.
write the retake, or do I have to fail it?
So the retake exam is for those who fail the first exam or who are sick with like a statement from a doctor, or who are in a stay abroad as part of their study program, and those people actually consulted me already via email. So the retake is really a retake and not an option. Please be here for the first take. And I mean, it is kind of, I know it will be a crowded, busy 1 or 2 weeks full of exams, but this is how studying works. This is already factored in. Don't worry, this is not the first exam we are doing here. And it is completely doable in 90 minutes, and it is also completely doable if you pay attention to the lectures on a weekly basis. So the best preparation for the exam is to be here on a weekly basis and listen to the lectures. There was something I wanted to say. Yeah, if you are not available for the first exam because you are sick or because you are abroad and have a statement testifying that you are abroad, please send an email to my office. Mühlhoff@uni-osnabrück.de, and please make it clear already in the subject line that this is about the exam in the lecture Introduction to the Ethics of AI, and that you, for a reason that you state, want to participate in the retake. And if you have unavailabilities concerning the retake, you can also mention that. My secretary will collect that, and then we will find a solution that accommodates all of you in terms of fixing a retake date.
Is there any chance that maybe next week you could give us some, I don't know if examples, questions, or just maybe some hints to which direction the exam is going? Because I can see either this is going to be, we could be asked a lot of very specific questions about definitions, or we could also be asked a lot of questions along longer over the broader concepts where we need to free-form answers.
The exam will be a multiple choice exam. You will not be writing text. You will just ticking boxes. And each session of the lecture will be covered with 4 questions, maybe. I try to make it not only definitional questions, but more also sometimes also judgment questions. I'm a little hesitant, or I feel a little bit unable to really show example questions here. Maybe I can look if I have an old exam that I might show you. I'm not sure. I cannot promise now, but it will be closed questions with options to choose from. Yeah.
Will it be important to know like the specific names? Like this is what Foucault said.
There will be some names, yes. I tried throughout the lecture to make it, to stress things that I find worth remembering, while I'm aware that I also sometimes just kind of touch upon things more briefly that will then not be maybe primarily relevant to remember in the exam. I mean, I know that there are a lot of details sometimes here in the lectures, and I think if you watch the lecture with somehow kind of a judgment like, okay, what is now the most important 5 things that I learned from this lecture? I think that is a good strategy. I will not kind of trick you by answering the most, like the footnote on slide number 45 question, something like that.
Okay. And if we reread the book, there, like every topic is in there.
The book? Like, you mean the... No, not all topics are in there. Like all the tech ideology, fascism topics are not in there. And also the book is not a textbook in the sense of lecture notes. For instance, the detailed explanation of Rechtsstaat or the GDPR is not in the book. I think if I were you, I would just flip through the slides again.
Yeah, because so the concept of the question you will ask are the most important ones, and they are also on the slides because the most important concepts are on the slides.
Yeah, there will be nothing in the exam that's not in the slides. Or I hope so. That would be surprising to me. So I think I mean, in the book there is also a level of detail that I did not cover here in the lecture, and that will definitely not be covered in the exam. No, I think it's the best idea is to go through the slides. I mean, it's many slides, I know that. It will be 800 slides or something, but you can flip through them maybe, I don't know.